divorce take? How long does my divorce take? I wish that I could grant you a magical divorce that would happen as quickly as possible with as little drama as possible. But you know what? There are so many things that depends on, and mostly it depends on you, okay? You and your spouse, okay? And so look, I'm just adding on factors, and opposing counsel, and meaning the counsel that your spouse gets or does not get. So if they don't have counsel, let me just tell you how long that's gonna take, a really long time. So don't think that's a quickie divorce, okay? And it depends on the lawyer you get. So if you get the right lawyer who's gonna really listen to your goals and understand that you don't need a Ferrari divorce, because you don't need a Ferrari divorce. You need a Toyota divorce. A Toyota divorce can still take a really long time if the two of you do not play nicely in the sandbox together. It is absolutely in everyone's best interest to get to the table quickly. So what we do to hasten the divorce is and get you through this as quickly and painlessly as possible is we make sure that we get you on board with getting all your financial documents together right out of the gate. We reach out to your spouse or opposing counsel and say, hey, let's get mediation set really quickly. There are some amazing mediators in family law. You've got to go to mediation every single time. 9 times out of 10, we're going to get it done at mediation. If you impasse, meaning you can't resolve all the stuff that you're fighting about at mediation and you want to go to a final hearing, then the next factor here is getting a final hearing time or trial time on anyone's docket. Any judge is backlogged to high heaven, and you're going to be at least a year out, typically. I think I had one that we just set. It's already been going on for a year. We set it for trials in December. That's the earliest we could get. And next year's trial calendar isn't even open yet. So divorce is not fast. It can be fast if you and your partner, your spouse, are being respectful of one another, are not goading one another, are not intentionally pushing buttons. Then we can get your document, your financial assessment done. You can look at your financial affidavit, figure out the numbers like child support and alimony, if that's at issue, how to divide up any of your stuff. And then we can settle as much of that as we can before we even get to mediation. Let's get the stuff you agree on done before we get there. And then we go to mediation with just the big stuff that you really, really, really don't agree about, and you really need some help negotiating and facilitating that. And there are some really skilled mediators who will help you with that, and we love them. And so that's it. That's the quick route. And that's still going to be 3 months, 4 months. I'd say average is 6 months. But again, so many factors come into play. So just to recap that, how long is your divorce going to take? I don't know. It could take 3 months. It could take 6 months. It could take a year. It could take ages. I don't know. No one knows until you come in to meet with us and we start to unpack it. So people will often ask us, hey, I don't know anything about divorce. I'm terrified. I don't know what to do. What's the process? So simply, you can either get a lawyer or not. So if you did it on your own, the process is you go to the courthouse or download a form, petition for dissolution of marriage with or without minor children. You file it. You're going to have that served on your spouse. So this is where somebody comes to the door and says, you've been served, just like you see on TV. Okay, that has to happen next. Then your spouse has a certain period of time, in Florida's 20 days, to answer and or file a counter petition asking for whatever they want. So in that petition, you're saying, hey, I want the kids this much time. The marriage is irretrievably broken. And I want, this much time sharing. I want alimony, etc. I want the car, etc. Whatever you want. Then they have an opportunity to say, admitted, denied. I don't think you are entitled to any of that. And then they get to say, hey, well, here's what I want in a counter petition. And then you, as the spouse that filed initially, will have the opportunity to file an answer to that counterpetition. So that's just the pleading process. That's just the documents that you're filing. And I will say that those form documents are not necessarily going to cover everything. So because if you do this yourself, there is an opportunity to miss some things. But next, after the petition, there's something called mandatory disclosure. Mandatory disclosure is exactly what it says it is. It's mandatory, and you are disclosing all of your financials to your spouse. Now, you might think, well, that's silly, but they already know everything. Well, most of you don't. One of you is probably the person who's all in charge of the finances, and one of you is not. So this is an opportunity for both parties to say, hey, where's our money? Where is our stuff? Where are our assets? Where are our liabilities? Do you have 10 credit cards that I don't know about that you've charged up to high heaven? So this is where we look at all of that, and there's no lying. And if we think somebody's lying, this is where a forensic accountant might come in and take a look at it, okay? Then once we have that done, somebody fills out a financial affidavit and says, here's my living expenses. This is what I make. This is my income. This is how much I spend to live. So that gets filed with the court too. Next up, mediation. Hopefully we're going to mediation with all that financial stuff done. And potentially if you've got minor children, we've already started working out a really good parenting plan that you guys are thinking through together, right? So then you go to mediation. Even if you're representing yourself, if you are going through this process and don't just walk in the court with your agreement already signed, you're going to go to mediation. If you are representing yourself, you're probably going to have a court-appointed mediator. They are likely not going to be a lawyer. So just be aware of that. So they may not be as facile or as skilled at negotiating that process. If you get to mediation and it all falls apart and you're still fighting, next up is more discovery. Discovery is the process of finding things that matter. So let's say somebody in mandatory disclosure, we found out that somebody indeed did have 10 credit cards, and that said 10 credit cards were being used to pay for a spouse, or no, I'm sorry, the 10 credit cards were being used to pay for travel for a girlfriend and house her in an apartment in Colombia. Whatever. So let's say that that's the case. Then that money would be money that you would be able to identify and say, well, wait, that's going to have to come out in the equitable distribution. We need to identify that you have waste. It's called wasting marital assets. So we would look at that there. So there might be some questions or requests for documents where we're asking for that. Then finally, once we sort out all the evidence, because discovery is really the process of figuring out what evidence do we need to prove what we need to prove to get what we want at trial. That's it. So then we're going to go to trial after that. And then the judge, who you're going to see for a total of, 2 to 4 hours, maybe sometimes a day, that person is going to decide your entire fate for the rest of your life with this person and your children. And I'm just going to say that's not what you want. You want to settle it at mediation. If you want to go into your divorce and keep it simple, or as simple as it can be, the best thing you could possibly do for yourself is to treat it like it's a project, and you gather all the stuff you need before you even meet with the lawyer. We would love that at Brava Law. So this means you're going to get together, you're going to pull together electronically and find a folder, find a hard drive, find a flash drive, wherever you want to put it. Put all of the documents that you're going to need. And you can go out to the Florida Supreme Court website and download something called mandatory disclosure and then a certificate of compliance with mandatory disclosure. And it's going to list every single thing that you're going to need to gather, starting with your pay stubs, your bank statements, your savings account statements, your 401k, your IRA, the last 3 years of your tax returns, your health insurance, who pays for it, where does it come from, the declarations page of any life insurance policy that you might have for you or the kids, who are the beneficiaries, that kind of thing needs to be on there. So all of those things, your credit card accounts, credit card debt, you need to list out any assets that you have. So let's say somebody owes you money on a promissory note. You lent them money and there's a promissory note. We're going to need to see that. We're going to need to see your business tax return. So if you have a business, either on your own, with your spouse, or with a third party, we're going to need to see 3 years of corporate tax returns for that. We're going to need to see, things like your vehicle, lease, as a debt. We're going to need to see any other debts that you might have and assets that are significant. And there's going to be a place to not only list the documents, but then to list the tangible things on that certificate of compliance with mandatory disclosures. This is a great opportunity. Let's say you had a family trust and you had that trust before you got married, you kept it separate, you still put that on this sheet and you make sure that you've accounted for it so that when you do meet with the lawyer, everyone has total transparency and visibility into who has what, when did this asset or liability accrue? When did the person whose name is on it get there, et cetera? And remember, it's not just the things that are joint. If it's in your name, so for example, 401ks, just in your name, it's not yours if you came into that 401k during the course of the marriage. Now, that's a nuance, but these are the things you got to gather ahead of time. Okay. We would love you. You would be our A+ client. And then if you also followed our naming convention for naming them, we would even love you more. What is mediation? Because your lawyer's going to start talking about this, or somebody's going to start talking about it fairly soon if you're beginning this divorce process. Mediation is what it says it is. You bring in an intermediary, someone to go between you about the things that you don't already agree on. Now, in family law, you are required by the family law rules of court to go to mediation at some point. You are not required to solve anything there. You don't even have to show up and try. So one of you may show up and just say, screw this, I want what I want to go to court. I highly recommend that you don't go that route, because you're just gonna spend money and time and stay in one another's lives, complicating your existence even longer. And there's no need for that. A really skilled mediator will help the lawyers and the parties prepare ahead of time by saying, hey, let's go ahead and get together. And this is where your lawyer will help you with this too. And we will send it to the mediator. This is how you speed the whole thing up. Write out your marital settlement agreement in advance of the mediation. This is what we want. This is our working draft that's going to go back and forth between the parties, including the things like the parenting plan, child support. We've already done child support is a math problem. So we've already laid out what does child support look like. And and we're including that math problem. We're including the math problem of alimony in the marital settlement agreement and the parenting plan in advance of mediation. And the best way to approach mediation is to send all that to the mediator in advance, if not ahead of time, to opposing counsel. And again, work out what you can agree on before you even set foot in the mediator's office or Zoom room. So mediation is exactly what it says it is. It's coming together with someone to help you find a compromise. You're mad, he's mad, you think you're right, she thinks she's right, everybody's right. We want what we want. It wasn't fair. He did this, she did that. It's not fair. I want her to pay. I want him to pay. The mediator is skilled at reading the room, taking the temperature, and bringing parties together, bringing two people who once loved each other, by the way, or you wouldn't be here, who now maybe hate each other, and unpacking all the emotion and getting it out of there and saying, hey, don't you want to be done? Do you want to be done? We can be done today, but only if there's a little give and a little take, that we're going back and forth and we're making offers. This is not the time to just dig your heels in. It will take longer if you do that. Digging your heels in helps no one, especially your kids. Play in the sandbox with your spouse and listen to the guidance of your attorney and your mediator. You'll be done so much faster, and you can move on to, you can end this well so that you can slay your sequel. So if you have any questions about how to prepare for mediation, about the role that mediation plays, about how you can best position yourself to resolve your divorce quickly through an effective mediation, call Brava Law.